the jurors?
Oh, they're all here, Judge.
All right, we're just going to put something on the record first and then we can bring them in. Oh, no, we don't. You can have a seat. Yeah, we're good. No, 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 no.
20 years.
Okay.
50 years. Take the person and as we will one at a time.
All right, we're going to go on the record. Court is going to call 2022 CR 9807, State of Texas versus Vernon Dixon. Can I have parties announced for the record for the state?
Jason Garahan and Daniel Escobar for the state, Your Honor.
Defense?
Adam LaHood and George Schaefer for the defendant, Vernon Dixon.
All right. And are you Mr. Dixon?
Yes, Your Honor, if we
Just 1 second. That's okay. All right. So I'm sorry, if you could re-announce defense.
Of course, Judge, may it please the court. Your Honor, in discussing this with my client, Mr. Vernon Dixon has decided to voluntarily absent himself from this portion of the trial. Obviously, a verdict has been rendered as to guilt innocence. He has chosen not to be here for the punishment phase. We do have all appropriate stipulations signed and before the court, or they will be here shortly. Again, this was his decision. We respect that decision. He's not required to be here for that. And so we will be proceeding to punishment without Mr. Dixon this afternoon.
All right. And defense, did you have ample opportunity to discuss this with your client?
I have, Your Honor, and he has made the decision knowingly and voluntarily.
All right. Thank you. The next issue that we put on the record was with regards to competency. And I know that was previously placed on the record.
Yes, Your Honor. Just to recap briefly, a competency evaluation was conducted this morning by Dr. Michael Jumas, PhD. We had a hearing on this previously, but just to recap, it is the opinion of Dr. Jumas that Mr. Dixon is presently competent to proceed to trial. The defense is satisfied that he is competent, and we are not requesting any further evaluation on that matter based upon the testimony and advice of Dr. Michael Jumas.
All right. Thank you.
Thank you, Your Honor.
Is there anything for the state to put on the record before the jury's brought in?
No, Your Honor.
All right, then let's bring the jury in, please.
Yes, sir. I think it's in the book on page 4. Yeah, page 4. Yeah. Okay.
In just one moment. Before the jury's brought in, state and defense, have you had a chance to review the jury charge for punishment?
Yes, Your Honor.
Yes, Your Honor, we have.
Any objections?
Not from the state, Your Honor.
We do not have any objections, and just for clarification of the record, this is the one that on page 4, it does have language about the defendant voluntarily absenting himself from the hearing. And
Yes.
we have no objection as presented.
All right, thank you. All right, let's bring the jurors in. All right, everyone, please be seated. All right, ladies and gentlemen, this is the second phase of the trial. State, do you have any opening statements?
No, Your Honor, we'll waive the opening statement.
Defense?
The defense is fine waiving a statement, opening statement, Judge.
All right, State, do you have any evidence to present?
Yes, Your Honor. At this time, the state's can offer State's Exhibit number 41 is the waiver and stipulations concerning clause number 1993 CR 6163.
All right, if you could slow down just a little bit.
Sure, Judge. 1993 CR 6163 and 2006 CR 7214A. That's the defendant's waiver and stipulations concerning these.
All right, any objections to State's Exhibit number 41 that's been stipulated to?
No objections, Your Honor.
All right, then State's Exhibit number 41 is admitted into evidence without objection.
And Your Honor, permission to publish.
Granted.
And just very briefly, this is from the second page of the waiver and stipulations. It reads, I, Vernon Dixon, do hereby judicially confess and admit that on the 13th of December, AD 1993, in cause number 1993 CR 6163 in Bexar County, Texas, the defendant Vernon Dixon was convicted of the felony of possession of cocaine under 28 grams. And after the conviction in cause number 1993 CR 6163 was final, the defendant Vernon Dixon committed the felony of possession of controlled substance PD1 4 grams to 200 grams and was convicted on the 29th day of October AD 2007 in cause number 2006 CR 7214A in Bexar County, Texas. It was signed by the defendant.
All right, and with regards to those stipulations, defense, I realize it's a stipulation, but for the record to be clear, what was it your intention and your client's intention that those stipulations were in fact a plea of true to the enhancement allegations?
It was, Your Honor. The defense will stipulate as to the enhancement allegations presented, and it is our intention to plead true to those enhancement paragraphs.
All right, thank you. State, any other evidence or witnesses?
No, Your Honor, the state will rest.
All right, defense.
Your Honor, the defense will rest. We just have argument.
All right, thank you. Do both sides close?
Yes, Your Honor.
The defense will close.
All right, ladies and gentlemen, I'm going to read to you what's the charge of court for punishment. Again, you do not have to memorize this. You'll be given it when you get ready to deliberate. Charge of the court on punishment. Members of the jury, the defendant, Vernon Dixon, has been found guilty of the offense of murder as charged in count 1 of the indictment, guilty of the offense of unlawful possession of a firearm as charged in count 2 of the indictment, and guilty of the offense of tampering with physical evidence as charged in count 3 of the indictment. The habitual offender enhancement allegation in the indictment alleges that before the commission of the offense alleged above, hereinafter styled the primary offense, on the 13th day of December 1993, and cause number 1993 CR 6163, in Bexar County, Texas, the defendant was convicted of the felony of possession of cocaine under 28 grams. Before the commission of the primary offense and after the conviction and cause number 1993 CR 6163 was final, the defendant committed the felony of possession of a controlled substance, penalty group 1, 4 grams to 200 grams, and was convicted on the 29th day of October 2007 and cause number 2007 CR 7214A in Bexar County, Texas. To these above stated enhancement paragraphs and the habitual offender enhancement allegation in the indictment, the defendant has pleaded true. You will find the defendant has previously been finally convicted of at least 2 felony offenses as alleged in the habitual offender enhancement allegation in the indictment, and that the second previous felony conviction is for an offense that occurred subsequent to the first previous conviction having become final. You will so state in each of your verdicts that you will find true the habitual offender enhancement allegation in the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years in each count. In this case, evidence has been admitted to the effect that the defendant may have committed an offense or offenses other than that for which you have convicted him. The court instructs you that you may consider this evidence, if any, in determining what sentence is appropriate in the case at hand, but you may only consider the evidence if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses. Our law provides the defendant may voluntarily absent himself from trial if he elects to do so. This, however, is a right accorded a defendant. And in the event he elects to absent himself, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected to be absent during this punishment phase of the trial. You are instructed that you cannot and must not refer or allude to the fact that throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that the defendant may testify in his own behalf if he chooses to do so, but if he elects not to do so, that fact cannot be taken by you as a circumstance against him, nor prejudice him in any way. The defendant has elected not to testify in this punishment phase of trial, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to be fixed the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. With regards to count one, you are instructed as follows. The defendant will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole law may be applied to this particular defendant. With regard to counts 2 and count 3, you are instructed as follows. The defendant may earn early parole eligibility through the award of good time conduct. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. The defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed, or 15 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to this defendant, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. Suitable forms are attached hereto for your verdicts, if you should care to use the same. However, such forms are not intended to influence you in any way in arriving at your verdicts. In any event, each verdict must be unanimous in writing and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you ready to proceed with closing?
Yes, Your Honor, we'll reserve all closing time.
All right, defense.
Thank you. Good afternoon, ladies and gentlemen. This will be the last time that I get to speak with y'all. And again, I want to start how we started this whole trial, and that is to thank y'all. Thank y'all for your time, your service, and ultimately your verdict. We respect your verdict, and ultimately it was your decision. Without you, this process just does not work. I want to just talk to you briefly. I'm not going to take much of your time. You heard the evidence, and I think you understand the punishment range that we're facing here. Minimum of 25 years, and that's where it begins. This is because there's 2 prior felony convictions, which we have stipulated to. However, take a look at the prior convictions. They're both drug offenses. This is the first violent offense that Mr. Dixon has been convicted of, and this was a violent offense. And we respect your verdict in that matter. I just want to give you a few things to think about and consider before you go back and deliberate. And the state will talk to you after me. Vernon is 57 years old. 57. That means if we assess even the minimum punishment, 25 years, which is on the murder charge, in the charge, it tells you that it will have to be at least half time served, just 12 and a half years. So you take somebody that's 57, they're looking at minimum 12 and a half years. That puts them into their 70 years old. And parole is anything but a guarantee. Anything but a guarantee. This is nothing, it is far from guaranteed that the parole board may ever grant parole on anything. We ask you to consider that, consider the fact that we have a person that's 57 years old, not in particularly great health, and to consider what would be an appropriate sentence. I would suggest to you, and in fact, I would plead with you to please consider a punishment on the lower end of the range. Again, this isn't a 5 to life offense like it would normally be if there weren't for 2 prior convictions. This starts at 25 years, a minimum. If you feel the minimum's appropriate, we would certainly be appreciative. But I would suggest to you that even with a minimum sentence on this case, there's a very good chance that Mr. Dixon, quite frankly, will be dead in prison before he's ever given a chance or eligibility for parole. Ladies and gentlemen, thank you again for your time, your patience, consideration over this last week or so. I sincerely mean it. I know the state's going to talk to you, and ultimately we'll thank you again for your verdict and decision on this punishment phase. Thank you all very much.
State.
Yes, Your Honor. Ladies and gentlemen, I'll be the last person to speak with you. And I do respect your verdict, and I do appreciate your deliberations and your time that you've spent here for the last, I guess, roughly week or a little bit longer than a week. This is the last hours, or at least the last day, hopefully, that you will have to sit here and deliberate on somebody else's future and their liberty. But I just want to go over a few things with you. Is that you came back with guilty on each count. And for Vernon Dixon shooting Avante Boyce. Again, the range of punishment is a minimum of 25 years to 99 years or life on each count. And I'm going to tell you, these sentences are all going to run concurrent. Nobody's spoken to you about that. They're what we call stacked is not going to happen in this case. That means that they will run at the same time. So if you give life on count 1 and they give 50 years on count 2 and then 40 years on count 3, all those run concurrent. That means they each start ticking away the years as soon as he gets sentenced and sent away. So really, the one on the left and the one on the right are the same thing. Count 1, count 2, count 3, life. I'm going to tell you this. We're asking for life because of the egregiousness of this type of crime. Because remember, in the end, he committed this on his what he considered his own family, his son-in-law, in front of children. You remember the scene that the defendant fled from the scene. He fled off to Kansas. The defendant was running away from his responsibilities. His responsibilities, if you look at this scene with the children all over the crime scene, you see the yellow circle there. Those kids were coming home from school. If you look at the next moments before the shooting, there was children all over that scene. One in the car, which is Avante Jr. Another, Juju, which is on the right, sitting underneath that pavilion. Then the individuals getting out of the car coming back from school. During the shooting, Avante Jr. is in that car. Evie's in that car pregnant with his brother and Avante's unborn son. After the shooting, Evie's standing there with Avante Jr. After the shooting, she's walking out with her child in her hands, Avante's son. the witnesses. We want to keep our community safe. Think of Juicy, how scared he was. Yeah, he wasn't being cooperative, and maybe he's a homeboy of the defendant, but he wasn't talking for a reason, because that's a future danger, because he's going to be at fault, even though he didn't say everything that he should have said. Carl, independent witness, future danger, future harm. Evie, he shot her husband. Unique, which is his biological daughter. Donald, which is his son-in-law. Another son-in-law. Safety for the witnesses. The puzzle piece will show that this defendant is a future danger. Future danger to the children, future danger to the witnesses, to his own family, and to our community, the public in general. Let's seek justice for Avante Boyce's children. They won't be growing up with their father. Let's seek justice for a senseless murder, one of the most senseless murders that you probably will ever see, because somebody got upset, stepped out of a car when he had a choice to leave that scene, but instead, he could have shot that gun up in the air. He could have shot the car. He could have shot the dumpster. He could have shot anything. But he chose to aim it at another human being, which he considered family, and killed him. We're asking for a verdict of life on each count for the justice of Avante Boyce in this case. I do appreciate your time. I will tell you this, is that, like the judge said, and what Adam LaHood said, defense counsel, that parole is a possibility in this case. He will be paroled at some point, possibly. But if you assess life, the community, this family, these witnesses, those children won't have to fear Vernon Dixon anymore. So I ask from you as a jury, life imprisonment. Thank you.
All right, ladies and gentlemen, I will send you back. Again, the two alternates, you will be placed in a separate room. So if you need to remove your personal items from the room while you wait in the separate room, Deputy Mejia will take care of that. All right, everyone, please rise for the jurors. Everyone, please be seated. And I think the exhibits are the same except for the one exhibit that's been added. So if y'all want to turn that over to the court reporter.
Yes, Your Honor. Thank you, Judge.
Oh, you can give it to them.